in the morning. Playback speed is beautiful. We still have her talking. So we gave her 24, wow, 22 hours to breathe. So now she can get going again. Here we go, guys. Here we go.
I have to bring to the court's attention one final matter, which is not discussed in the brief. Mr. Douglas and I had been discussing the availability of certain photographs and certain negatives of photographs, and I believe apparently we've reached an impasse with regard to them. There were photographs provided to the prosecution which included those taken at Mr. Kardashian's house on the 17th, as well as those taken at Dr. Heisinga's, I believe it's pronounced, office on the 15th. Now, those photographs...
You've been provided copies?
We were provided copies,
Okay.
I guess, as far as we know, of all those photographs, but apparently they were lumped together. The other day I came down and asked Mr. Douglas and Mr. Shapiro, who was the only other defense attorney who they thought would be knowledgeable on that, to try and separate out those which were taken at Mr. Kardashian's house from those that were taken at Dr. Heisinga's. And Mr. Douglas and Mr. Shapiro were able to do so with regard to about 2/3 of those photographs. There still remain a set or a bunch of them with which they could not distinguish. Consequently, I asked if we could be provided with the negatives of Dr. Heisinga's photos. The reason for that request is because we had previously been informed, apparently I'm told, that they had lost the negatives of the photographs taken at Kardashian's house, Mr. Kardashian's house. So consequently, if we got Dr. Heisinga to bring in his file, which presumably would have the negatives that he took, so that we could go through the negatives and make copies for ourselves off of the negatives, which would provide much clearer pictures of the defendant's cuts and so forth, than do the photos, apparently photos of photos which we have. So one for that purpose, and two for the other purpose of separating out, so that we would know exactly which photos were taken at which location on which date, because as it stands, they were all given to us, apparently given to us together. Lastly, Your Honor, there were discovery documents given to us which we acknowledged receiving last Tuesday on the 20th. Included within those documents are handwritten notes from Dr. Henry Lee, which were made apparently on April 2nd, 1995. That's when they're dated. And they are notes of his observations, apparently, and perhaps others' observations, that's what they appear to be, of various aspects of the SOX, which are an issue in this case, as well as apparently some have to do with the Bruno Magli shoes as well. Throughout this discovery is mentioned that photographs were taken, including, and of particular importance, that this says micrographs. So apparently there were micro photos taken, is what I'm trying to get to. And we have not seen those, and we believe we have the right to those. And we may have a disagreement about that. I believe we probably do have a disagreement about that. I broached the subject on that particular issue before lunch today, and I think we do have a disagreement. But whether or not the defense intends to offer those photos as real evidence at trial, I think if they, given their placement within all these observations of apparently Dr. Lee, we have a right to those photos as part of the observations of experts and notes of observations of experts. And we have received many photos in this case along similar lines, where apparently photos which were taken during the course of an examination by an expert were turned over to us. So that is our position on that. But once again, I'm tired of coming before this court. I'm sure that the court is tired of hearing me. I'm sounding like a broken record with regard to our frustration at having the defense flagrantly, what appears to us be flagrant violations of the discovery laws, because we have simply not gotten what one would expect given all the reciprocal discovery laws, mandates, and the case law following it, and what the magnitude of this case would dictate.
Thank you. Mr. Ullman.
Thank you, Your Honor. I can state without equivocation, without reservation, that all reports that are in existence for any of the experts on our witness list that we intend to call as witnesses at this trial have been turned over.
So the only expert witness you intend on calling at this point is Dr. Gerdes?
That's not what I said, Your Honor. I said all reports in existence prepared by any of the experts we intend to call have been turned over. Some of the experts that we intend to call have not prepared reports, and we have not requested them to prepare reports. And that, I think, is where we part company with the prosecution's interpretation of the reciprocal discovery law. Reference has been made to the whole point of reciprocal discovery. The whole point of reciprocal discovery is simply acceleration, not disgorgement. The whole point of reciprocal discovery is to make available to the other side the materials that you have prepared in putting your own case together that you are going to put on as evidence in the presentation of your case in chief. The discovery law does not impose any obligation to prepare reports or statements. It simply requires the turning over of the reports and statements that are prepared in the routine of the preparation of your case. Now, Ms. Lewis has stated everyone's expectation is that experts write reports. I'm afraid that's just not true. That is not everyone's expectation. In fact, the prevailing practice among many, many defense experts is that they will not prepare reports unless they are specifically requested to prepare reports. Now, Your Honor, of course, is aware of the Sarah case. We're aware of it too, in which a court held that for a defense lawyer to instruct a witness whose routine practice was to prepare a report, not to prepare a report, specifically to avoid having to turn that report over in the course of reciprocal discovery, was contempt. But that case did not hold that there was any obligation for the defense to make sure that a report is prepared by every witness that they intend to call as an expert witness. And quite to the contrary.
Let me ask you this. Forgive me for interrupting you, but it would be my impression, let's take, for example, Dr. Lee, that it's the practice of Dr. Lee and his office in the state of Connecticut to routinely prepare reports on the cases that they consult on and the cases that they assist the state authorities in that state to prepare for trial.
I think Dr. Lee will speak to the contrary on that point, that when he is retained by the defense as a consultant, he does not prepare reports unless they are requested. And Dr. Lee is an excellent example because his relationship has been an ongoing consulting one in which he is frequently consulted as the evidence develops on an ongoing basis by the lawyers representing Mr. Simpson for the defense. It is not the practice to require him to put into a written report the results of all of his consultation. And at this point, we have not even made a determination yet as to what issues Dr. Lee will be called to actually testify as an expert witness. So the discovery law doesn't say to the defense, you have to prepare reports. It simply says you have to turn over the reports that you do prepare. So the question, and again in our moving papers, we have cited a case from the Ninth Circuit, incidentally the same court that decided the Sarah case, the case of United States versus Peters, in which the court reversed the imposition of sanctions of excluding an expert because a report had not been produced on the grounds that a report had not been prepared. And under the federal discovery law, which closely parallels the California reciprocal discovery law, there is simply no ruling by any court at any time that a court has authority to order the preparation of a report so that it can be turned over. And there's good reason for that, Your Honor. If that were the case, if the reciprocal discovery law were to say to the defense, you have to produce reports and statements so that they can be turned over to the prosecution for their use, we would seriously run afoul, I think, of the protections of due process. The whole concept of reciprocal discovery is not based on turning the defense into agents who are supposed to assist the prosecution in investigating the case and making evidence available to them. The whole concept is simply we want to accelerate the process and say to the defense, if you're going to put this stuff on in your case, then you're going to waive whatever privilege protects it anyway. Therefore, you might as well turn it over now so that we don't have to delay the trial, so that the prosecution doesn't get this stuff when the witness is actually called to the witness stand. The extent, I think, of the prosecution's misconception of the reciprocal discovery obligation is implicit in their position, in their moving papers, that simply putting a witness on the witness list means that automatically the defense has to turn over anything obtained from that witness, even if they thereafter elect not to call that witness as a witness. That somehow just putting the name on the list works as a total waiver of any privilege that might protect the information that witness later turns over to the defense. And that is simply not the law. In fact, that position was explicitly rejected by the Court of Appeal in the Rodriguez case that we have cited, in which the court held that even after you put your witnesses on the list, at the time a later report is produced, that report may be excised to exclude privileged material as to which that witness is not going to testify. And the Woods case, which is the only case cited by the prosecution for this remarkable proposition, held that in that case, because the defense had turned over a report, at that point, the contents of that report were waived. Now, I'm not suggesting that we have reports that we're sitting on, waiting to see what our experts are going to actually be called to testify to. We concede that as long as our experts remain on the witness list and we receive reports, and our intent is to put those experts on the stand to testify as to the information in those reports have to be turned over as soon as we receive them. And we are certainly going to do that. But if at any point we decide to withdraw an expert and not have that expert testify, at that point, any reciprocal discovery obligation disappears, because the only purpose of the reciprocal discovery obligation is to accelerate the presentation of what is actually going to be presented by putting the witness on the stand. It is not to make available to the prosecution some sort of windfall of new information that they might then put to use in terms of supporting their own flailing case in chief. With respect to the rough notes of the witness statements, we have turned over the rough notes because that's all we have. And again, there's no obligation that we instruct our investigators to go out and interview a witness and prepare a statement simply so that statement can be turned over to the prosecution if we don't need the statement in order to prepare our own presentation of that witness. Again, it's a consistent position in that respect. We have been accused of playing fast and loose with the reciprocal discovery law. And quite to the contrary, Your Honor, I think all of the cases that have interpreted this law have sent warning signals that we are treading on very dangerous thin ice from the perspective of the defense lawyer's obligation to protect the privileges that encompass the presentation of or preparation of evidence for the defense, and to proceed with great caution in terms of what you turn over, because once you turn it over, it's a waiver, and the cases make that quite clear. Once you turn it over, whether you put the witness on or not, you have waived the privilege. So it's incumbent on the defense to very carefully look at what we're turning over, and we are proceeding on that basis. And we have turned over all of the reports that we have received from the experts that we have on our witness list and intend to call as witnesses in the defense case. There may be witnesses who are on our witness list who will not be called. But the fact remains, until we have received a report and we intend to present that witness to produce the results of that report, there is no obligation to turn that report over to the prosecution. And there is no authority.
Wouldn't you say we probably cross that line when you issue a subpoena or have an agreement for that person to appear or be on call as a witness?
You know, I'm not even sure that a subpoena crosses the line in terms of
Isn't that likely?
requiring that witness prepare a report. What I'm saying is, even up to the point that they've taken the stand and been sworn, there is no obligation that they prepare a report simply so that it can be turned over to the other side. If we're prepared to put our witnesses on without reports, knowing that there's a risk, certainly they can get up and cross-examine, and they can say to our experts, "Doctor, did you prepare a report?" "No." "You mean you did all of this investigation and came to these conclusions without ever writing a report?" "Yes." And they can compare that expert testimony to the expert testimony that they presented and suggest to the jury that this expert presented by the defense perhaps is less credible because he didn't prepare a report. That's certainly an avenue that is open to them. But what I'm saying is, that's a decision that is our decision, and the law does not in any way implicate our right to make that decision, to say that we are prepared to put our experts on without having required them to prepare reports. Finally, we would note that everyone's expectation that experts write reports, Dr. Lakshmana never prepared a report. I think we're dealing here with a case in which the recent developments indicate just how fluid and dynamic the tactical decisions facing the lawyers trying this case are, and how in many cases those decisions are going to change as the evidence comes in. So it's certainly not our expectation that all experts write reports, and it should not be the expectation of the prosecution as well.
All right, any brief response, Ms. Lewis?
Yes, Your Honor, thank you. The defense is still laboring under this misassumption, and this is where we radically depart from the meaning of the discovery laws. They're under this assumption that they can wait until they finally decisively actually call Mr. Witness X, Dr. X, to the stand before they've conclusively decided they're going to call that expert and therefore turn over a report. And again, when Mr. Yeoman talks about not knowing exactly what subject matter Dr. Lee is going to testify to, he's making that same argument again. And that argument cannot be the law, because every defense attorney in every case could argue that and could thwart the whole purpose of reciprocal discovery when it comes to experts. There's a real problem with that attitude, and I don't think it flows. I think it's a matter of law. The law is to the contrary. Once they put the witness on the witness list, they've done that.
Do you have a case that says that?
Well, under Izazaga, footnote 11, when they reasonably anticipate calling a witness at trial, I think putting them...
Do you have a case that interprets that phrase?
No, I don't believe there is one in California. But I think...
So how can it be so clear? And is there a federal case that has an analogous statute, or the Oregon statute that has a case that says that that's what reasonably likely to call?
No, Your Honor. The Parker case that Mr. Yeoman alluded to, which relied on the federal rules as well as a Hawaii statute, the wording of that statute, which the court interpreted the plain meaning of, explains that decision. The federal rules as well as the Hawaii local rule in terms of discovery of experts' reports provide that the defendant shall permit the government to inspect and copy or photograph the following. And they list experts' reports and so forth. And what the Ninth Circuit said in the Parker case is because the statute says it shall permit the government to inspect and copy or photograph it, it must have been making reference to something tangible already in written form. And hence there is no obligation under that statute to reduce an oral communication to writing.
Love you
We don't
lost.
have...
Just
Our statute is not worded the
move
same.
on.
Consequently, its plain meaning is different from the plain meaning of the wording of this statute.
I gotta go.
They're not
I gotta
analogous.
drive my daughter to
In
work.
addition to the
I'll be
statements
back.
of experts that our discovery statutes talk about, they talk about the defense having to provide the results.
Excuse me, maybe I obviously didn't make myself clear. Well, my question was reasonably likely to call as a witness. What triggers that standard? What is that standard? Is it when a subpoena is issued? Is it when the actual witness list is prepared? Do you have any case authority that defines that term?
I don't have any, there is no authority that I'm aware of that specifically delves into that issue. In Woods, however, the court does address it. The court addresses the defense argument. There is no case, I believe, in California that specifically defines that yet, that discovery law is still being interpreted.
I was wondering if you found anything in the federal statutes or the Oregon statute.
I have not, Your Honor.
Right.
The Woods case, in the Woods case, it's still right on point where it says, finally, the defense protests the vice of acceleration is that disclosure must be made solely to preserve the option of calling the witness, even though not all reasonably anticipated witnesses are actually called to the stand. At least in the case of confidential statements, the public defender in Woods argues there should be no waiver until the expert testifies. And the Court of Appeal in Woods held, we sympathize with the position, but cannot accept the argument as a general proposition without doing damage to the statutory objectives of ascertaining the truth, saving time in trial, avoiding the necessity of postponements, and protecting against undue delay. So the Court of Appeal, the policy behind requiring the defense to disclose those witnesses it reasonably anticipates calling at trial is to require that discovery to be turned over. So while there's no case which construes it specifically as far as what the court is talking about, there is the whole policy of the law, and the policy is explicated as it is in Woods and other cases. I'm reminded apparently that there have been defense experts going on national television saying they will testify in this case. I seem to recall Dr. Lenore Walker saying that on a Larry King live show.
Have you received any of the underlying testing information that was
We did, Your Honor,
discussed?
shortly after the court ordered it. We received, or informally ordered it, or maybe it was formal. We did receive, I know that. We have received the raw data of the testing results. We have never yet received any kind of report from Dr. Walker with regard to her analysis or interpretation or anything of that data. And we are wondering, why isn't that forthcoming? If she's bragging on national TV how she's going to be testifying in this case, surely she must have an idea of what she's going to be testifying to. So, Your Honor, the discovery law requires this disclosure so that those things can happen which it seeks to promote, and that is the ascertainment of truth, to save time and from delays happening or necessitated because of the failure to provide timely discovery. So all those things warrant the court finding that by placing these witnesses on their witness list, they did that for the purpose of preserving the right to call them. So therefore, it demonstrated as a factual matter, that they reasonably anticipated calling them for trial. I've argued that my reading of the statute, that should be as a matter of law, but it's also as a factual matter, and the court can so find with regard to this case, that they made that factual determination. Otherwise, why would they put those witnesses on their witness list? They clearly did so because they wanted to preserve the option of calling them, because it was reasonably anticipated, and that's the loose language of Mississauga. It's not strict language, it's very loose language. They reasonably anticipated calling them at trial. It was likely they would call them at trial. And Mississauga does establish the standard to that extent that it allows for a looser standard than the near certainty or certainty that Mr. Ullman argues to this court should be required before they have to disclose statements. Now, when they talk about civilian notes and so forth, oddly enough, throughout most of the several months of the beginning of this case, the defense was, when they eventually provided them, we didn't get them timely, but when they finally gave us witness statements, their investigators were able to write coherent statements. Many of them were short and to the point. They were not, most of them, the ones that we have gotten, are not lengthy, detailed, complicated things for an investigator to write out. So it's strikes us as suspicious, and it is suspicious that why is it now, suddenly with these last 10 or 12 witnesses that we get all these rough notes on, why are we only getting rough notes now if that's their general practice and procedure? Why haven't they been doing that all along? They've been writing statements all along, and their investigators have been writing statements of witnesses all along. Suddenly now there's been a change, and we're getting only these rough notes which are incoherent, and we're unable to rely on them. So we believe we deserve more, Your Honor, and I'm here again with my palms open asking the court to please enforce the discovery laws and require the defense to do what the law obligates them to do.
All right, thank you, counsel. I accept as a premise in this matter Mr. Ullman's representation to the court at this time that all expert witness reports that have been produced and that are in the possession of the either the expert witness themselves or in the possession of defense counsel have been turned over to the prosecution of those witnesses that they intend on calling, that the defense intends on calling. I have already expressed to counsel my skepticism that so many defense witnesses would not prepare reports, especially given the national stature of so many of these witnesses. It seems unlikely to me that that's the case. However, I do acknowledge that this trial has been very dynamic and very fluid in the way that it has progressed, and that things change day to day, moment to moment. And I can see clearly strategies shifting on both sides. So whether or not a final determination has been made to call a particular witness, I can, as a former trial lawyer, understand that that decision changes from day to day. The prosecution, Ms. Lewis, you make the argument that I should look to the policy and the spirit of the statute and enforce the policy and the spirit. The problem is the policy and the spirit is for the appellate courts to determine, not for the trial court. I'm bound by the particular language of the statute, and as a trial court judge, I can't go beyond the statutory language. There are many flaws in 1054 of the Penal Code, and I suspect one of the outcomes of this particular case, no matter what the outcome, will be a legislative change in 1054 that will statutorily require the preparation of reports. But that's not supported by the case law, and it's not supported by the statute. The court's previous order does direct the defense to turn over all reports as soon as they become available. That order stands. And I previously warned the defense that if expert witnesses are called and if I find that there's been a subterfuge, those witnesses will be precluded. That ruling stands.
Thank you.
All right, let's go to the motion to quash the subpoena.
Good afternoon, Your Honor.
All right, Mr. Darden, good afternoon.
The people have filed moving papers seeking to quash the subpoenas for Melissa Decker, one of my personal law clerks, and Deputy DAs Alan Yokelson and Terry White. While it's true that the defense can issue a subpoena on a hope and a prayer that the witness will appear and provide them information, the witness isn't obligated to appear and testify unless the defense can establish, or make a showing rather, that the witness can offer some material or relevant and admissible information. In this situation, as I understand it, these staff members of the DA's office can offer the defense nothing at all in terms of material information or evidence or testimony. They have nothing to offer this court or these defense lawyers in the way of anything that is relevant to these proceedings. Apparently, the defense hopes to somehow impeach Mark Furman's testimony, and I can understand why they might want to try and do that. He was a very effective witness. He did not buckle under the pressure, and I'm sure that the jury found him a very credible witness. Now, they seek to undermine that testimony by calling these DA employees. Their offer of proof, or the showing that they intend to make, apparently is based on an article in Newsweek magazine, specifically a March 6 article. They've cited that article or quoted a portion of it to the court in their response to our motion to quash, and I would ask that the court take a close look at that article. It provides no source, no named source for the information contained in the article. It doesn't even say that the source is anonymous. In fact, no source is mentioned at all. There are a couple of quotes contained in the article. One of the quotes is attributed to a source close to the prosecution, not a prosecutor, not a member of the DA's staff, but a source close to the prosecution. And then that individual apparently, and that is if you can believe the Newsweek writers, goes on to state that Mark Furman was a difficult or defensive witness during an alleged mock cross-examination. Well, let's say that's true. Let's say that Furman was difficult and defensive. Well, that's an opinion. That is the opinion of the source close to the prosecution, and if that was the opinion of any member of my staff, then that opinion is privileged. It's not relevant. It's
Privilege
not
under the work product privilege?
under the work product privilege. It would not be admissible. There's a second quote that's attributed to a prosecutor
We're
familiar.
not talking admissibility, we're talking discoverability.
Okay, I understand that. I understand that. But it wouldn't be material or relevant as well.
Well, there's different standards for discoverability and admissibility.
Yes, yes. There's a second quote, which is attributed to a prosecutor familiar with the case. And that person, assuming he is a prosecutor, assuming he is familiar with the case, and I doubt that anyone is really familiar with this case unless they sit here every day with us and witness what goes on in court. That prosecutor speculates that if the information contained in the article is true, that a jury might conclude that Mark Furman planted evidence. Well, how is that material? Or relevant or admissible? It isn't attributed to any member of my staff, and it isn't attributed to the DAs and DA staff members that they seek to subpoena. Nor, given the context of this information, given the fact that it is from some unnamed source, assuming that there is a source, nor is it likely to lead to evidence, discoverable evidence that will be proven admissible at some later time. There's nothing in the article to suggest that we as prosecutors are in possession of any information that is inconsistent with Mark Furman's testimony. They make these base allegations, of course. Of course they do that. But they don't attribute those allegations to us. Now, we as prosecutors have a duty, I think, to advise the court in the event that a witness testifies in a manner that would constitute perjury. And I understand the perjury statutes in this state. I have indicted police officers on perjury allegations. I have investigated police officers for perjury. I have participated in Board of Rights hearings on perjury issues, and I understand the law on that. And I suspect that what the defense really wants to know is whether or not Mark Furman told us that he used the N-word in the past 10 years. He testified that he did not use the N-word in the past 10 years, and had I any information otherwise, I would have advised the court. And I have not advised the court because that situation has not arisen. Now, counsel for the defense and the prosecution have entered into an agreement, which was alluded to by Ms. Lewis a moment ago, and that is that attorneys' notes are not discoverable. I think that if we look at the spirit and the purpose of that agreement, if our notes aren't discoverable, why then are our thought processes discoverable? Why should we be required to come and testify under circumstances like these? It turns the agreement on its head. We have nothing new to give the defense. We have nothing to tell them that they don't already know, that they don't already have in discovery. If they want to know if Mark Furman ever used the N-word throughout his life, then they have the same 1981 and 82 psychiatric reports that we have. We discussed that before. Okay, and the court ruled that that evidence was irrelevant and inadmissible. We don't have anything else new. As for the article's characterization of that event as a mock cross-examination, and I want the record to reflect this so that it is understood, when Mark Furman was here on one weekend, the air conditioning in the upper floors in this building were turned off. We had to go to the only floor we could go to where the air conditioning was on and where someone had a key that happened to be on the 13th floor. And when we walked into the grand jury room that day, I said, geez, I'm going to regret this one day. And we have. But at any event, we have no new discovery, Your Honor. My staff has nothing to offer this case. These defense attorneys, no new evidence whatsoever. And I ask that the subpoenas be quashed. They cannot show this court that we have material, or relevant, or admissible evidence.
Thank you,
Thank
Mr.
you.
Gardner. Mr. Ullman.
Your Honor, to put these subpoenas in context. All three of the subpoenaed individuals, we have information, were present during this unusual Sunday afternoon grand jury session with Detective Mark Furman. Detective Furman, Your Honor will recall, was questioned about this session during his cross-examination when he appeared as a witness in this trial. And he testified that the session was a very brief one. He said 20 to 30 minutes, that it was very casual, that he was eating a submarine sandwich while various questions were discussed. And to quote his testimony from the transcript, page 18768, by Mr. Bailey, "Can you tell me, just yes or no, were any racial slurs used in that experience that day?" Answer, no, there weren't. Question, not a single one? Answer, no. Now that varies significantly from the description of this session that appeared in Newsweek magazine. And I call Your Honor's attention to the quotations that are attributed to district attorney sources in their description of what happened in that Sunday afternoon session. The attorneys were hammering Detective Mark Furman as the questions turned to the issue of racism and to his disaffection as a police officer. Furman became uncomfortable. He admitted that he had made racial slurs in the past. He conceded he was profoundly disappointed in a criminal justice system that too often fails to punish the guilty. Furman played right into the hands of the defense. This time, the interrogation of Mark Furman was only a dress rehearsal. It took place, Newsweek learned, during a mock cross-examination staged by the prosecution last week when the Orenthal-James Simpson trial was in recess. The article goes on to say, quote, "A source close to the prosecution said Furman came across as a difficult and troubled witness, that he became defensive and agitated." The article then asks, could Furman's performance help a juror believe that the detective had planted the infamous bloody glove at Simpson's Brentwood mansion? That wouldn't be a big leap, says a prosecutor familiar with the case. Now, when a national news magazine cites as their source individuals on the staff of the district attorney's office.
What credibility can a court put in anonymous sources?
Well, the question, Your Honor, is whether we now have enough of a basis to pursue this and ask to speak to the district attorney personnel who were concerned, and if they refuse to speak to us, to subpoena them as witnesses.
Well, Mr. Ullman, let's assume that if a witness statement is made to a prosecutor, and that statement contradicts testimony in court, and let's assume that I believe that there's a Brady obligation under that scenario to disclose, how does the court, and assuming further that we have the unusual situation that you're talking about calling deputy district attorneys involved in this case as witnesses, so I have the same problem only in reverse of the Kardashian situation, how do you suggest I deal with that?
Well, there are
And
a number of...
this assumes that I find Newsweek to be a credible source of information.
Right. There's one important distinction, and that is that with respect to Mr. Kardashian, there is an attorney-client privilege with respect to the consultations between Mr. Kardashian and Mr. Simpson.
No, we're not talking about that situation.
Well, here we're talking about a mere witness. We're not talking about any implication of any lawyer-client privilege.
No, I'm asking you, how do we proceed? You're missing the point. In both situations, you're asking to call as a witness in this trial counsel for one side or the other.
Right.
That raises very delicate issues, I think.
I would suggest that Your Honor proceed the same way you did with Kardashian. We made Mr. Kardashian available to the prosecution to be interviewed.
They did not, Your Honor. I have to interrupt. I'm sorry. They did not.
No, you don't need to interrupt, Ms. Wilson.
Well, I believe that there was an effort made to ascertain precisely what it was they wanted to ask Mr. Kardashian. We are simply asking that we be given the opportunity to talk to the prosecutors and to the district attorney personnel who were actually present during that session. That session is not a privileged consultation. We're not asking to impede on any work product privilege. We're not going to ask these witnesses what their thought process was or what their evaluation of Mark Furman was. We're going to ask them what happened and what was said in that session that could conceivably contradict and impeach what Detective Furman testified to when he was called as a witness at trial. And I think Your Honor is correct that there is a Brady issue lurking here. In fact, if what the Newsweek article says is true,
Well, why don't you address my specific question? How do you propose the court proceed as making those assumptions?
well, I would suggest the court proceed by ordering that the district attorney personnel that we have subpoenaed submit to interviews by the defense. We have requested an opportunity to interview them, and the response was simply they are overburdened. They're too busy to talk to us. We believe if they're going to stonewall us and attempt to cloak this entire session in the grand jury room with some sort of impenetrable wall of secrecy, then we have a right to bring them into court and out of the jury's presence question them. I think that would be a ludicrous use of this court's time to have to go through that exercise simply because they won't sit down and even talk to us. Now, it may be, and we'll assume that when they sit down and talk to us, they're not going to lie to us, just as we assume they're not lying to the Newsweek magazine. If they're going to give us information about what happened, not their impressions, and not their notes, just simply an account of what happened in that session, it may be that we don't even need to call them, that there is nothing there. But the published account attributable to sources in the district attorney's office suggests that there indeed may be something there. Certainly enough of a suggestion to create an obligation on our part that we pursue it. And that's all we're attempting to do. The subpoenas are a product of the attempt of the district attorney to simply stonewall us and say, we're not even going to sit down and talk to you. We're not going to make these personnel available to be interviewed because they are overburdened. And I think that just strains credulity.
What is the return date on your subpoenas?
They expired long ago, Your Honor.
Well, it's not going to make it moot in the sense that it won't recur. We'll just have to resubpoena them if the date of return has expired. But I think the simplest solution to this problem is simply to permit us to interview these personnel.
And the specific issue are statements made by this witness that are contrary to the testimony here in court.
That's correct. That's what we want to inquire into. What statements were made in the course of the grand jury interview and prep session that would contradict his testimony at trial.
Right.
Yeah. The questions would simply relate to their observations of what occurred in the grand jury room.
Recognizing that there's attorney work product interwoven throughout that. It's not that, I don't think
Well,
it's that simple.
we're not interested in the attorney work product. We're not interested in their impressions. We're not interested in whatever notes they were working from in terms of questioning the witness. This is a legitimate pursuit of evidence that is highly relevant and highly probative as to the credibility of one of the key witnesses who has testified in this trial.
Thank you, Mr. Ullman. Mr. Dard, do you have any brief response?
Briefly, Your Honor, we understand our Brady obligations, Your Honor, and we have met them. I'm just surprised to hear that the defense feels that if their experts go on TV and say they're going to testify, that they don't have to produce a report. But if a magazine writer writes an article using unnamed sources, we somehow have an obligation to provide them, to provide ourselves to them and submit to an interrogation by the defense. That is simply ridiculous. We have nothing at all to offer this jury or this court, or this defendant and his lawyers regarding Mark Furman. As far as the description of what happened in that mock cross-examination, they say they want to know what happened. They heard the testimony. They saw the witness. Okay, so they know. Now they know a little bit more because I told them a little bit more. It would be unfair, completely unfair, given the agreement that we have with the defense and given this fishing expedition that they want to go on, to require us to submit our clerks and our special assistants and our lawyers and our staff to a defense interrogation. It's unfair. I'm sure it is unprecedented, and we object.
Thank you, counsel.
Your Honor, if I could just call the court's attention to one portion of the record. Mr. Darden says that everything that went on in that session we learned from Detective Furman. I would invite the court's attention to page 18764 of the transcript, question by Mr. Bailey. Can you remember even one of the questions that these three lawyers put to you? Answer, no, I do not, sir. Question, not a single one? Answer, no.
Sure.
Ms. Lewis advises me the questions are work product, but I also give the court an additional citation.
Questions may be work product, but the answers given to them are not.
And that citation is People v. Hollander, 194 Calat 2nd, 386,
What does that stand for?
page 391. It stands for the proposition that the defense can't subpoena witnesses in the hope that those witnesses might somehow impeach a prosecution witness. It stands for the proposition that they have to show that the witness has some material relevant and admissible information. And as for Mr. Kardashian, I think the court understands the factual distinctions in his situation.
All right. Another interesting situation we have here. Counsel, first of all, as a beginning premise, I accept that the court does have the power and discretion to quash subpoenas in situations where it's appropriate to do so. But this is a matter of discovery at this time, not a matter of admissibility. And I agree with the defense argument that given the publication in a nationwide, a magazine of nationwide distribution that is considered to be a news source rather than a tabloid type source of information, that triggers an attorney's obligation to conduct further investigation by means of the discovery process, and I accept that as a given. I also accept that if a witness has made statements to counsel during the course of preparation, statements that are contrary to the testimony in court, that is discoverable. And because of the parties who conducted this questioning, it also becomes discoverable under the aegis of the Brady doctrine. So I find that there is a sufficient prima facie showing that there is potentially discoverable information available through Messrs. Yokelson, White, and the law clerk, Miss Decker. But I also recognize that these are counsel for one of the parties here, which is a touchy situation similar to the Kardashian matter. And the court will therefore conduct in camera its own questioning of these persons. However, I'm going to request from the defense recommended questioning of these witnesses. I'm going to direct Mr. Yokelson to appear in this courtroom on Tuesday, June 27th at 8 a.m. I'm going to direct Terry White to appear in this courtroom on Wednesday, June 28th at 8 a.m. and Law Clerk Decker on Thursday, June 29th at 8 a.m. And the court will conduct in-camera questioning of these individuals on the record.
Your Honor, if I can indicate this, Ms. Decker is studying for the bar exam.
Bad timing. Okay.
At this time.
That is... All right, why don't you find out when she'll be available?
Okay. And as for Mr. Yokelson and Mr. White, can we have additional time, approximately 1 week before the court begins its...
Why do you feel that's necessary?
So that we can consider appellate remedies, Your Honor. I think the court will get until Wednesday to come back and advise the court of whether or not we intend to seek an appellate remedy.
Well, I would imagine that whether or not you're going to seek appellate remedy is something you can decide between now and Monday, don't you think?
I said Wednesday.
I know, I'm saying, but don't you think you could figure that out between now and Monday?
It's 2:30 on Friday afternoon.
Well, I assume that the district attorney's personnel work until 4:30 on Fridays.
This district attorney works until, well, hours much
All
longer
right.
than 4:30.
Counsel, we'll do this. I'm going to direct the defense to submit to me a recommended questioning by Monday the 26th. Mr. Darden, you can come in and tell me what the prosecution's position is on Monday. If you feel appellate remedies are necessary, then I will consider a motion to continue the hearings of the 27th and 28th. All right, and then find out when Ms. Decker will be available. And my anticipation is that these hearings, the camera hearings, will take approximately half an hour, is my guess at this point.
Okay.
All right, that's the order of the court. All right. Mr. Morrell.
Regarding the questions that be proffered. Are we going to be allowed to take a look at the question?
Oh, yes, absolutely.
Thank you.
Your Honor, before we embark on the transcripts, I do want to ask the court to at least take under submission the ruling on the photographs. Apparently, the defense is not willing to provide Dr. Lee's photographs that he took of
I'm sorry,
observations.
that wasn't one of the
It was
items
not
that
included in the
briefed.
brief. Did you want me to put it in writing, Your Honor?
Yeah, why don't you put it in writing?
All right, thank you.
All right. Before we launch into this hearing, I received a response regarding Mr. Morell's motion from the defense. Mr. Darden or Ms. Lewis, are you going to speak on behalf of the people on this matter?
I am going to speak on behalf of the people. We have not filed a written opposition. There is at least one case I found citing. I know the supplemental petition from the ACLU was untimely, having been filed yesterday. I will waive our objection on that basis if they'll waive the problem with the court taking into submission until it has an opportunity to read the case I've decided to it.
Sounds fair enough.
Can we see the case in here?
Yes, it's a brand new and the latest advance sheet, Second District Court of Appeal case, People versus Feagin, F-E-A-G-I-N, at 34 Calat 4th, 1427.
What volume of the advance sheets is in?
I don't remember the number, Your Honor. It's, I just got it within the last few days.
May I ask to borrow that?
I got it.
Sure.
I'm aware of the case, Your Honor.
All right, Mr. Morell. Good afternoon.
Good afternoon, Your Honor. Thank you very much. First, let me introduce myself. Douglas Morell, M-I-R-E-L-L, volunteer counsel representing the ACLU Foundation of Southern California. Joining me here in court is an individual who assisted me in the briefing on this, David Crochetier, C-R-O-C-H-E-T-I-E-R-E. Also, as the court knows, Ms. Sager is present as well, and she filed, as the court indicated, a joinder on behalf of 9 media entities, including all of the major television networks, the Los Angeles Times, and others. Since the court is aware of defendant's joinder, let me just simply note that also present in the court today, and I received a joinder from him, although he arrived too late to submit it to Ms. Robertson, is Rex Reeves, who is appearing on behalf of dismissed juror Francine Florio Bunton, and Ms. Florio Bunton is here in court as well. I want to thank the court first for allowing us this opportunity to appear before you and for hearing this motion.
Well, Mr. Morell, forgive me for interrupting
Sure.
you, but I have familiarized myself with the motions filed, and let me cut to one particular issue that I'm interested in. Sure. It is true that a number of the jurors who have been dismissed from this case have voluntarily made their identities known to the public through the news media and have acquiesced to interviews and, in fact, have affirmatively gone out and sought to be interviewed. Some have sought to financially gain from this experience. Let's assume that perhaps the court's interest in protecting the privacy of those individuals has disappeared since those individuals have voluntarily decided to put themselves in the public eye. However, a number of the dismissed jurors have not so made themselves public figures, have declined to be interviewed, have in fact been traumatized by the excesses of the news media in hunting them, and those individuals maintain that posture to this date. Should I make a distinction between those two?
Well, Your Honor, I think there are issues that may be raised that unfortunately we are not in the best position or really any meaningful position to address, because it may well be the case that with respect to the dismissal of certain of those jurors, there may be, and we have acknowledged this in our briefing, there may well be instances where releasing certain portions of transcripts of dismissal hearings might well implicate personal privacy interests and might well constitute an unwarranted invasion of an individual's personal privacy rights in a particular case with respect to particular information. I, however, cannot accept, Your Honor, the notion that a blanket order which precludes the release of any portion of any of the transcripts concerning any of the hearings, concerning the dismissal of any of these jurors, is appropriate. Under the governing law, it's not narrowly tailored. There's no compelling interest that's being supported by that.
Let's not even get into that argument.
Okay. But
Do you agree that there are perhaps some instances of personal privacy that the court should continue to protect? Let's assume that I'm willing to disclose those transcripts that involve individuals who've decided that their privacy is not of interest to them.
yes, no, I understand that. Let me say this. I think that with respect, for example, to, let's take the 2 jurors whose names have not been publicly disclosed as of this point. With respect to those 2 jurors, I would not expect, for example, that the court would release portions of the transcripts concerning their dismissal, which identify them by name, if there are any such portions. However, I do believe, Your Honor, that there is every reason, and no good reason not to, release those portions of the transcript which describe the reasons why these jurors have been dismissed, which describe the evidence that was before the court, which describe the court's rationale for dismissing these jurors. So with respect to them, for instance, I would say that at this point in the trial, it probably is appropriate to retain their names in confidence. With respect to another category of jurors, Ms. Hampton and Ms. Chavarria, who I think are the two who have elected not to speak to the press in any meaningful way, although Ms. Chavarria, I believe, did give an Associated Press interview 1 or 2 days after she was dismissed. But in comparison, at least, that's meaningful. Their names are already known. They have already, unfortunately, Your Honor, this may be a digression, but in the case of Ms. Hampton, I must say that I believe that her dismissal and the way in which the court handled that dismissal is an example, a prime example, in fact, of where the court's on-the-record description of the dismissal decision and the rationale and the contemporaneous release, perhaps, of the transcript, sensitively redacted, if there are personal privacy issues there, could have avoided the kind of feeding frenzy that ultimately occurred, not only at Ms. Hampton's home, I might add, but at the homes and businesses of a number of other jurors, because as the court will recall, the court did not disclose which of the jurors it had dismissed. And so the press, as inventive as they are, were going about seeking to try to find out what juror might be being dismissed. So my concern with respect to those jurors is that what the court ought to be doing in that case is, yes, perhaps reviewing the transcript as quickly as the court is able to do, determine whether those transcripts contain any portions which do implicate a clearly unwarranted invasion of personal privacy, and make appropriate redactions of those transcripts at the time. And with respect, I think, though, to the other 6 jurors, Your Honor, those who have gone more or less fully public, Ms. Murdoch, Mr. Knox, Mr. Kennedy, Ms. Harris, Ms. Florio Bunton, and Mr. Craven, I think that it is doing no one a service, particularly the jurors themselves, the former jurors themselves, that is, to have their transcripts and the records of their dismissal proceedings kept sealed. Because what has happened, as the court well knows, is that a pervasive regime of rumor, speculation, and innuendo has taken the place of facts. And I think, Your Honor, too, that that speaks to a second issue which we raised in our initial papers, which is the importance of the court actually articulating on the public record, and perhaps even in the presence of the jurors, the reasons for its dismissal decisions at the time those dismissal decisions are made. That is, interestingly enough, one of the salient aspects of the Fegan case that has just been cited to you by Ms. Lewis. In Fegan, what happened is that the court, in fact, disclosed on the public record what it is that, why it was that it made a decision to remove a particular juror. And I think that practice, buttressed and bolstered by the practice of Judge Oderkirk during the much more communally sensitive Reginald Denny beating trial, where Judge Oderkirk contemporaneously released the transcript of juror dismissal hearings. Ouderkirk, I'm sorry. Where Judge Ouderkirk did that, Your Honor, he, I think, performed a public service, because he, even though the dismissals occurred during the midst of jury deliberations, he eliminated the possibility that there would be speculation or guessing about why it was that a particular juror had been dismissed and what the motivating factors were.
Do you know Judge Ouderkirk's present position on this issue?
He has not communicated with me, nor I with he, Your Honor.
I think he regrets that situation because that particular juror received death threats and was erroneously identified as being some other person, which resulted in problems with that other person. There were significant problems in the disclosure of that information.
Well, Your Honor, with respect to the jurors who have already been publicly identified here, misidentification is not a problem. And with respect to, I have no information one way or another, Your Honor, that would permit me to comment upon the other aspects.
Just a
of what you said.
digression.
Yeah, but in any event, I don't know what the prosecution's view on the underlying motion is. But Your Honor, I think that the Fegan case, if they're going to cite it to you, has no bearing upon this issue whatsoever. It's simply the court's, as I understand it, the latest statement on the basic underlying issue of manifest necessity versus good cause and what might constitute that. But I think it is interesting, Your Honor, and I commend the court to footnote number 6 in the case, in which the court lays out, albeit with ellipsis, a 7-paragraph description of why it is specifically that this particular juror was dismissed. And, Your Honor, I must say that by contrast, what's happened in this case is that we have either seen a total absence of any description whatsoever, in the case of Ms. Jeanette Harris about why she was dismissed. The court did not even state its usual dismissal for good cause.
I know that this is very intriguing, and I shouldn't pause it right now. I know this. However, I wasn't here for the best part. I wasn't, so I have to stop it. Yo, submarine sandwiches are delicious. He got to do his testimony eating a submarine sandwich. Yes, he did. Why, though? Why, when you buy a sub from anywhere, it tastes good. But when you make it at home, see, okay, normally, if you put my dish of whatever next to what you can buy outside of this house, my dish wins hands down every freaking time. Every time it's the more delicious by far. It just tastes good. Spaghetti, meatloaf, chicken, beef, name it. Tacos, name it. Mine, submarine sandwiches, though. I have yet to create a sub in my kitchen that tastes as good as the worst sub that I get outside. Why? Why is that? Josh. So, Furman apparently went through his questioning before trial and everything in the grand jury room. I don't know if you remember that part. While eating a submarine sandwich. A submarine. I love subs. I do. Okay. All right. This is very important stuff, especially for people like me. So let's get back to work. I don't know why you guys went on this tangent about subs. This is a murder trial.
Cause, found, rationale. But with respect to other jurors, Tracy Kennedy, he is the only juror who has been dismissed from this case where both sides were solicited and acquiesced publicly here in open court to that dismissal, and the court found abundant good cause. Now, what was so different about Tracy Kennedy than about any other juror that caused the court to do that in that case and in that case alone? I don't know, but the problem is that the absence of the court's articulation of a rationale for that dismissal decision and for all of the other dismissal decisions is that the public has been left to speculate. And speculation, Your Honor, in the context of a public trial is just not what ought to be encouraged. And I think both the people under Proposition 115 and the defense under the Sixth Amendment and Article 1, Section 15 of our California Constitution each have a right to a public trial. And the cases that we provided to the court already manifestly demonstrate that a clear component of a right to a public trial is the right to know what's going on at all stages of the proceedings. And if those proceedings are not such that the court feels comfortable providing access, although in some of the cases we provided to you, the court will note that even in juror dismissal hearings, there have been courts which have concluded that the press ought to be physically present during those dismissal hearings, ought to have access to those to even post-trial investigations. But that's not what this motion is about. We're not here requesting that the media at this point, or that the public, be allowed into those hearings. What we are saying is that at bare minimum, what this court ought to do to ensure the public trial right is to contemporaneously, promptly as possible, release the transcripts of those proceedings and related developments.
Do you think I should at least require that notice be given to these jurors who have maintained, or at least a notice that unless I hear from them, that I'm inclined to release the transcripts, redacted for personal information?
Well, Your Honor, I don't know of any case which has ever said that jurors ought to have some ability to control what it is that is released about them and their conduct during the course of trial.
Or do you think dismissals for misconduct is sufficient to waive any
I
right to
do,
privacy?
Your Honor, I do. And we heard from Mr. Dershowitz last Friday that this is not, and I must accept the fact because I've not been privy to any of the transcripts. Mr. Dershowitz said last Friday that this is not the kind of case where dismissals are for typical reasons, illness, death, things of that character, extreme family emergencies. He has asserted, and I appreciate that the prosecution has contested at least to some extent, the fact that each of these dismissals is a dismissal for misconduct. And I think what that means, or at least what it says to me, is that when jurors are engaging in misconduct, they are violating a public duty, a public trust. They are violating their solemn oath to do what it is that you have instructed them to do. And I think when that is found, and when the court finds good cause to find that that has occurred, then I think there has been a waiver, and I don't believe that it is necessary for this court to make inquiry of the jurors.
I can think of one situation, two situations, where I did not make a finding of misconduct.
Okay? All the more reason to release the transcripts, Your Honor. If a juror is being dismissed for reasons other than misconduct, and they are not, and I would hasten to add that even if they were being dismissed for what Mr. Dershowitz had characterized as traditional reasons, maybe there's some other reason other than misconduct or traditional reasons. But
No, we had two traditional reasons.
okay, if there are traditional reasons, I would suggest that there are ways of sensitively redacting the transcript of those proceedings to the extent that they really do trench upon matters that are private. And I would also suggest to the court, and this was something we suggested back in April when we initially wrote a letter to you on this specific subject, I would suggest to the court that when in the future it is, I hope it doesn't have to engage in the process of determining whether or not additional jurors are to be dismissed. But if that unfortunate eventuality should come to pass, then I would suggest that what the court ought to say at the outset of the proceedings is, look, to the individual juror, the transcripts of these proceedings are going to be made public, but they will not be made public until after you're dismissed. I think that's the way of remedying that problem on a going forward basis. Hopefully there won't be any need to deal with that on a going forward basis. But in any event, I appreciate the court's forbearance on this, and I would simply reserve the opportunity to respond to counsel with respect to whatever they may say about the Deacon case.
Thank you. Excuse me, Ms. Sager? Good
He didn't
afternoon,
talk
counsel. Do you
about
have anything
subs
additional
once.
to add?
Just very briefly, Your Honor, I think Ms. Morrell has covered most of the points. The only thing that I would say in addition to that is that the hearing last Friday is, I think, a clear demonstration, along with all the other problems he raised, of the problems that arise from holding proceedings behind closed doors. You have serious accusations being made by counsel for the parties against one another, and the public is left without any knowledge whatsoever about whether there's merit to the accusations or whether the proceedings that the court is engaged in are fair, and the proceedings, as they ultimately will result, is a fair result. And all of this has resulted, I think, in some kind of taint on the proceedings, which can only be solved by releasing the materials and letting the public know what is going on. And that's precisely what the Third Circuit Court of Appeals indicated in the Simone case, that once the taint has been raised, that then it is critical that the public be advised of what's going on so that they are assured that a fair proceeding is being held. And whether or not, as you mentioned to Mr. Morrell, some of the jurors have not been released for misconduct, I would think that that would be an even greater impetus for releasing information to the extent the court can do it as to why they were released. Because if statements are being made in court, the jurors are being all released for misconduct, then I would think those individuals would have a concern about the public having a perception of them that is a false perception. And to the extent those have been released for misconduct, then the public should know that there is justification for those releases, and not that, as some accusations have been made back and forth, that they're being released for reasons other than good cause. And the public is vitally interested in this. I've received a number of calls, as I'm sure the parties have, and probably the court, with people saying to me, as one woman did last week from Northern California, what are they hiding? Why don't they want us to know? There must be something there. And for the same reason that voir dire is held in the open, so the public knows that a fair process is being held and the result is a fair result, I think it's equally important that the public know when a juror is dismissed what the reasons are for that dismissal. And I'd add nothing else, Your Honor. I think that the time has come for release of these materials. There's no reason not to release them at this point, and as opposed to waiting till the end of the trial or some future date. The jurors who have been released have already been the focus, as Your Honor mentioned, of a great deal of scrutiny, and if a further delay occurs before the release of the transcripts, they'll simply be the focus of additional scrutiny down the road. So it's not as if people are not going to wonder what has happened and why they've been released. If there's been misconduct, the public should know that. If they've been released for other reasons, the public should know that as well. So I would join in Mr. Morrell's motion and urge the court to release the transcripts at this time. If there's a need to redact because of some inherently personal privacy interest on behalf of one of the jurors, then only those portions be redacted, that it must be redacted, just as the standards for voir dire would have the proceedings completely open, but for any inherently private material that must be done in chambers. Thank you, Your Honor.
Mr. Dershowitz.
May it please the court, this is a triangular issue. The defendant has a Sixth Amendment right and the related California provision to a public trial. The media and the public and the ACLU have a First Amendment right, and jurors may have an interest in privacy. With all due respect, the state does not have any rights and probably doesn't even have a sufficient interest to give them standing to participate in this discussion. That perhaps explains why up to now I don't even know what the state's position is. When I asked what the state's position is, I was not told by the state, but then I was told by a representative of the media that the state will surprise us by coming in and opposing this request. I'm not sure the state even should be given standing to make any argument because in some respects it does not really involve any interests that they can specifically state. In very typical cases, there's a conflict triangularly between not the juror on the one hand and the public and the defendant on the other hand, but often between the defendant and the public. In many of these cases, the defendant does not want the transcript revealed, and then you have a constitutional clash, the First Amendment versus the Sixth Amendment, because the defendant can waive his Sixth Amendment right to a public trial within reason. In this case, the defendant most definitely asserts his Sixth Amendment right. He wants this case to be entirely open. He wants this proceeding to be open, as you know, Your Honor. He requested that he be present. That has been turned down. That's for a different time and a different day. But he wants the public to know what went on there, and for a very important reason. In my experience, Your Honor, in more than 30 years of practice, I have learned that when the public is allowed to hear about these proceedings, the public can be extraordinarily helpful to the defendant, particularly in a case like this one. Sources of information from the most unpredictable venues come to the attention of the defense. And if this transcript were to be made public, we can expect people to come and call us and tell us about information they may have which we do not now have. And part of the reason for a public trial is so that, because the proceeding is not held in secret, the public can participate through the defense and indeed through the prosecution as well, if there's information that they would want to have made available to them. So our request is that the entire proceeding be made public. If Your Honor feels that there is any particular juror, and I think, Your Honor, and perhaps we have a disagreement here, and this is a hard disagreement to moot in public, we believe that there's only one juror who has any arguable privacy interest in this case, and that all the other jurors were in fact dismissed for non-traditional reasons. Your Honor may have a different view of that. That is something that we can't debate without getting into the specifics of the transcript. I've read the transcript. You were obviously there, and I would love to argue with you about this now, but I can't because we can't reveal this in public. We are denied the ability to make some of our case precisely because this has been closed to public discussion. And so we assert an independent right. We assert a right separate from the right of the press. We assert a defendant's Sixth Amendment right to have this material disclosed so that it may aid in his defense, so that he may be given the opportunity to supplement the arguments that we made last week and arguments that we may have to make at some future time relating to the fairness of this trial and the correctness of Your Honor's rulings and the actions of the prosecution in leading to some of the challenges at issue here. As Your Honor notices, I am skirting around issues, and that's a difficulty that we have when we publicly argue about a matter that's subject to seal. But Your Honor knows what I'm talking about. I hope I know what I'm talking about, and the problem is that nobody else can be fully advised as to what we're talking about, and Your Honor, that's precisely the problem. Thank you.
All right, thank you, counsel. Ms. Lewis?
Your Honor, can I just be heard one moment? I am here for Ms. Floria Bunton. My name is Rex Reeves, appearing on behalf of Ms. Floria Bunton.
Right. Good afternoon, counsel.
Thank you, Your Honor. Ms. Floria Bunton strongly supports the application to have the transcripts
Josh,
unsealed.
listen.
And hers is
Eat a sub. Go get a huge submarine sandwich. Not too far from here. Far enough that I'm not going to go get one. Probably because I can't remember where it's from. But not too far from here. Like within 2 hours. Maybe a 2-hour drive, maybe. Which is a long way to go for a sub. I agree. You're not gonna think this is yummy when I tell you. But there is this special sub. It's a Thanksgiving sub, and on it is turkey and stuffing and cranberry. Stuffing is dressing. Stuffing is, you guys know what stuffing is, right? I'm not saying a word that isn't used everywhere, right? Bread, bread, croutons. They're not croutons, but it has everything on it from a Thanksgiving dinner on this sub. It is unfreaking believably delicious. I mean, I tasted it for the first time and it was old. So the person who was bringing it to me was stopping through on their way back from like Maryland from the beach. And they stopped and they got it. And then they, came home and unpacked, showered, blah, 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 blah. And then I tasted it like that night when I met him. Oh my gosh. I don't even have words to tell you how delicious this sub is. It is so good. It's very popular. It's not like a small secret. Like, people drive hours to get these subs. I just don't happen to remember the name. I've never actually driven there myself. But, Josh, your day will go so much better if you could just hop on a plane. A private jet would be fastest. Come and get this sub and then get to work. You won't be tired at all because it's a sub.
This is a case study in the very concerns that the court was speaking to earlier. Ms. Florio Bunton has not made tremendous efforts to make herself available to the press, although she has spoken to the press. She's tried to maintain some semblance of a normal life, although the press has been camped out at her house continuously since her dismissal, and she's tried to address some of the questions of the press. However, there has continued to be this tremendous amount of speculation that Mr. Myrell spoke to about the reasons for Ms. Florio Bunton's dismissal from the jury in this case. This speculation has ranged from whether she had a book deal, to whether her husband had met with a literary agent, to whether she was hitting other jurors or trying to trip jurors, or even allegations that she's just plain a racist. These allegations are utterly and totally false and, in fact, slanderous. One of the bases, apparently, it's unclear what the basis, Ms. Florio Bunton doesn't know the basis for her dismissal, but one of the bases apparently was a letter that has been discussed in court, I believe, last Friday, the source of which is apparently contested. As part of unsealing the transcripts in this case, Ms. Florio Bunton requests that any documents upon which the court has based any decision to dismiss any jurors, and in particular Ms. Florio Bunton, that any such documents and any such letter that's been brought to the court's attention also be released to the public. Ms. Florio Bunton believes that she was in fact sabotaged in an effort to get her off the jury by unknown persons, and the only way we'll be able to fully explore this, and the public will be able to fully explore this, and the only way Ms. Florio Bunton will be able to try to find out why she was in fact dismissed from the jury or possibly targeted for dismissal from the jury is to not only obtain the transcripts but also obtain this mysterious letter or any other documents that the court may have come into possession of in the course of its investigation or interrogation of jurors in this case. And to the extent that the court is concerned about any kind of privacy rights, I cannot speak for any jurors other than Ms. Florio Bunton, but Ms. Florio Bunton certainly waives any privacy rights that she may have in connection with the transcripts of the proceedings. In short, Your Honor, we concur that the public has a right to know. We certainly believe Ms. Florio Bunton has a right to know why she was dismissed after giving up 5 months of her life in this case. She wants to be vindicated. She believes she will be vindicated, and that the release of these transcripts and the release of any documentation upon which the court based its decision will be a necessary first step in achieving that vindication.
Thank you, counsel.
Thank you, Your Honor.
Ms. Lewis.
Your Honor, the prosecution is in a, not quite between a rock and a hard place, but in a difficult position. If we had our druthers, I suspect that we would like to have these transcripts all unsealed. And I say that only in terms of our druthers being those that our very limited self-interest would protect, to show that Ms. Clark's done nothing wrong, Mr. Darden's done nothing wrong, no DA investigator has done anything wrong. But, Judge, we have to look at the overall larger picture here. This feeding frenzy is a phrase that was used a few minutes ago, and as the court is well aware, and everyone else, that's what this entire case has been about. And from the beginning, from the 13th of June on through to the present date, in terms of the extreme and really unwarranted press interest in this case. Now, the reason why I cited the Fagan case to the court, and apparently Mr. Dershowitz has not had an opportunity to read it, because it does address the defendant's Sixth Amendment right to an open trial. And it does hold in this particular case, which happens to be Second District of the Court of Appeal, that the defendant in that case waived the right, if there was any, to have the public participate in that aspect of trial because it consented to the procedure initially. The facts are very similar to this case in that case, the defense initially agreed to the in-camera procedure, and it was only after several jurors were questioned that the defendant suddenly took umbrage and wanted to have them open, wanted to have the defendant present. This case holds that the defendant had no right to be present under those circumstances, having waived it initially. It also holds that the defendant had no Sixth Amendment right to access by the public with regard to the juror misconduct, or juror removal, I should say, issues. It also held, our Second District did, that even assuming the Sixth Amendment public trial guarantees applied to the juror removal proceedings, and it says that we don't think they did, but even if they did, the presumption of openness is rebutted by showing that exclusion of the public was necessary to protect some higher values, such as the defendant's right to a fair trial, or the government's interest in preserving the confidentiality of the proceedings. I interpret that, Your Honor, as our obligation to the people of the state of California to help do what we can to preserve the integrity of these proceedings. This court, during the jury selection process, which seems like years ago now, but several months ago, assured these jurors that it would do what it could in its power to maintain confidentiality and anonymity over the particular jurors.
How do you respond to the argument, though, that if there's been an allegation of misconduct, and if the court has found that there's sufficient misconduct to excuse that juror, that that person, by committing misconduct, and in fact, during the course of some of these proceedings, one party or the other has urged the court to have the juror dismissed, referred to the Attorney General for prosecution?
I don't think it is required of the court, nor do I think it would be a good exercise as a matter of precedent and public policy for the court to have to make that kind of factual determination juror by juror, which is what would be required. I don't think a waiver necessarily applies because not only are we talking about any particular juror, we're talking about third parties' comments with regard to things happening with those jurors. I mean, the investigation has not been in a vacuum with regard to these jurors. I mean, the court has not just talked one-on-one to particular jurors without other information available. So by even assuming that those jurors had waived that aspect, the other surrounding information has not been waived and should not be waived. I'm concerned because this may well have a chilling effect already, given the media scrutiny, rather, and the media as distinguished from the public, but the media scrutiny on the jurors and the juror issues is really unwarranted, and this is likely to have a chilling effect on the public out there. The public is who we depend on in selecting our jury pool, and as the court well knows, we depend on their willing cooperation to come to court to serve. We do not have the resources to follow up and put people in jail who ignore summons to jury subpoenas, and I'm not suggesting the court should even do that, but it does have a chilling effect. This is not the only trial going on in this county, nor is it the only high publicity trial. There's another high publicity trial regarding two brothers, which is scheduled to start later this summer. Now, what this court does in this case may have a direct bearing on the ability of that court to obtain jurors and a representative cross-section of the community in that case. The jurors in this case were indeed promised that anonymity. I don't think they've waived it by the findings the court has made with regard to some of those jurors. And I think looking at the overall picture in the scheme of things, the court owes it to the integrity of this process not to turn around and betray the trust of the jurors, whom it has promised, all of them, individually and as a group, betray that trust that the court, that they have now, that the court has instilled that in them. I mean, the court offered up this anonymity as one reason for their participation on this case, that the court would try and protect them. Well, what are all of the jurors going to think, and all of the panelists and prospective jurors out there in the community going to think if the court suddenly does an about-face and just releases that all?
So I've got jurors out there writing books about this. Hardly a privacy interest worth protecting, wouldn't you say?
Well, Your Honor, with regard to something...
we got jurors running around in limousines to talk shows. Hardly a privacy interest.
I am suggesting further than the privacy interest of those particular jurors who may be, writing a book despite not having indicated any intention to do so, at least overtly and openly and candidly, to the court or counsel during the voir dire process. I'm concerned about
the public's entitled to know the unusual currents that are swirling in amongst the jury panel here? Wouldn't you agree that this has been an atypical case regarding the voir dire process and who's willing to serve on this case?
Well, it has been atypical, but I'm asking the court to ensure that it does not get even further...
Weren't you surprised when we asked people, are you willing to be sequestered for 6 or 8 months, and we had volunteers? Didn't that mildly surprise you?
It is clear to me personally, I'll speak only for myself, that many of these prospective panel had hidden agendas, and that was certainly a fear going into this case. We didn't anticipate, however, that it would result in an avalanche of volunteers, virtually. I'm exaggerating, but, and so many people wanting on the jury. I'm tempted to mention the issue that the defense blew out of proportion on an offhand comment with regard to polygraphing jurors. I mean, Your Honor, there's nothing the court could have done more than it already did in trying to ensure the integrity of the individual jurors who were eventually selected. But my concern is for the process and its perception. We know that an overwhelming number of people out there, they're already perhaps not very high perception of the criminal justice system has already been impaired by many aspects of this trial. And this feeding frenzy by the press is only to the derogation of the rights and the interest in the public, the interest in the people of the state of California, in seeing that the people have a fair trial and seeing that the man accused of a double murder has a fair trial. And the Figgin case does go directly to the defendant's inability at this stage of the proceedings to require the court to release those transcripts.
All right. Thank you, counsel. Madam Reporter, how are you doing? All right. Mr. Morrell, any brief response?
Very brief, Your Honor. There are just a couple of points that I wanted to raise. The Friday hearing last week, as our supplemental memorandum makes clear, and I'm not going to belabor the point, there are bona fide disputes. We've just seen one here in court about the court's belief that there are 2 jurors who were dismissed for traditional reasons, and Mr. Dershowitz's view that there's only 1.
Well, I was there, he wasn't.
I appreciate that, Your Honor, and perhaps because you were there and because you contemporaneously heard what went on, we would be able to resolve this dispute rather quickly.
Well,
if
Judge,
the public and the press were given the opportunity.
that's right. If you would have showed it, we all would have been there. And we deserved to be there. Remember that day, guys? Remember that day? Came and went. Came and went, and we were like, where's this juror? We get a juror today. No, we didn't get to see it. But now the chickens have come home to roost for Judge Ito, because he didn't let us see it that day. We all wanted it. That's all we wanted for Christmas.
To read what transpired where you were there. Now, they may agree with Mr. Dershowitz, who says he's read the transcripts after doing that. But in terms of the basic notion of the public's confidence in the integrity of this court's decision-making processes and in the confidence that it has to have, particularly in light of the pending motion that the defense has filed, claiming that the prosecution is targeting jurors for dismissal, a motion which if it's bona fide, if it's true, is outrageous. It would be outrageous for the prosecution to be doing that. But whether or not that's happening, and the integrity and confidence that the public has to have in the court's ultimate determination upon the bona fides of that motion is integrally interlinked, I submit, to the disclosure of the transcripts of what actually went on. I submit that it's impossible for anyone, any member of the public or the press, to have confidence in the decision-making process of the court if the transcripts are not released, both in the context of the dismissals initially and in the context of the ruling on the pending defense motion that was argued here last Friday. Your Honor, I think the court had it right, precisely right, when on April the 12th, it conducted the post-dismissal interview of Jeanette Harris. And at the end of that interview, Sheriff's Department Commander Patrick Holland objected, as the court may recall, to the release of the transcript of that interview. And this is what you said, this is what the court said in response. The court said, this is a public court, this is a public inquiry. Because of the nature, I decided to make it a closed hearing, closed to the press, closed to the public for purposes of taking the testimony here today. But I'm under extreme pressure to make this transcript public, and I frankly don't see any compelling reason not to make it public at this point, close quote. And the transcript was duly released the following morning. That, we submit, is an archetype of the practice that should have been followed up until now. But since one ought not to reject wisdom merely because it comes late, in the words of the late Justice Felix Frankfurter, I would suggest to the court that there is a way of undoing the damage that has been done and a way of resurrecting the reputations of the jurors who have been dismissed and who may have been, and whose reputations may be being besmirched by the wave of rumor and speculation that has flooded the airwaves and has flooded the print media. And that's by releasing the transcripts now of those jurors of the dismissals of those jurors. And I do want to join Mr. Reeves' comment that to the extent that there are other evidentiary matters, I have no idea what they may be. The court last Friday said there was no letter with respect to the alleged anonymous letter from a literary agent concerning Ms. Florio Bunton's.
I don't think that's what I said.
No, that's what the official, or that's what both the unofficial and the semi-official versions of the transcript say. But I was actually confused. And
I may have said that wasn't the reason.
Okay, well, the transcript currently reads there was no letter, so the court ought to take a look at that. But in any event, what's clear is that there is a divergence of view on that question between the court, perhaps on the one hand, the defense on the other hand, which Mr. Cochran said there was no anonymous letter that his office received, and the prosecution. Ms. Clark said there was an anonymous letter, and we have phone logs, too. All of those are issues
We're speaking about 3 different things.
Well, okay, that may well be, but that's probably my fault. But it's my fault only because the transcripts haven't been released and we don't know precisely what's going on here. And there really isn't a good reason why we don't. I think the question of what the prosecution's obligation is, I think the prosecution's obligation is clear, and I'm surprised and I'm disheartened that they've not joined this motion because I think they could have had their druthers And I think they should have had their druthers and should have joined the motion because there is a constitutional right in the state of California under the Crime Victims Justice Reform Act of 1990. There is now a public right to a public trial. That's a right held by the people of the state of California. That's who the prosecution represents. Article 1, Section 29 of our state constitution says that that's a right that ought to be taken into account. And I heard nowhere in Ms. Lewis's argument any acknowledgement that that occurs. But what I did hear is a claim that, well, maybe jurors are somehow going to be chilled. But I think there are a couple of responses to that. One was the response that Your Honor gave, that this is in fact an atypical case, and that no one, not legislators in Sacramento, not members of the County Board of Supervisors across the street, ought to be taking the Simpson case as an archetype of anything. This is sui generis, and if the case were possible to throw into a legal dictionary definition, I think this would be it. This is not the case from which to extrapolate rules of general applicability. This is a case that breaks the mold in many, many, many ways. And I think the public is smart enough to understand that, and to understand that this is an extraordinary case in which people are doing extraordinary things. Jury consultants tell us that jurors don't want to be sequestered. Yet here we have jurors who volunteered to be sequestered. We have a situation, though, Your Honor, where by failing to disclose these transcripts, what we may be chilling is something that's much more important. We may be chilling the fact that jurors, the public's notion, the public's understanding that jurors are engaging in misconduct. And I think one of the things that we do affirmatively want to chill, Your Honor, if anything else, is juror misconduct. And I think to the extent that the public understands why it is that jurors are being dismissed, if it's 10 or 11 of the jurors who are being dismissed for misconduct reasons, the public has a bona fide reason and a right to know why that's occurring. And I think the court can easily satisfy that concern, and in doing so, serve other interests as well. Serve the court's own interest in ensuring the integrity of the system, serving the public's interest in the integrity and the fairness of these specific proceedings, and in any verdict that may ultimately be passed upon by these jurors. And it also serves the interests of the jurors themselves, because it is they who have had to bear the brunt of responding to what may be inflammatory and irresponsible and reckless allegations made about the reasons for their dismissal. That would all be remedied. Those problems would vanish once these transcripts are released, and this would be a non-issue, and the court would not have to see me again on this issue. And I appreciate, again, the court's indulgence.
On this issue.
Your Honor, just
I reserve rights, Your Honor.
1 minute, if I may, Your Honor.
Certainly.
We believe the Fagan case supports our position. I have read the Fagan case within the time it was given to me and now, and indeed that raises a different problem. We don't think the prosecution should be allowed to come in here, having had a case, knowing what their position is, and simply state to the court on the day of the argument, this is our position, this is our case. Talk about reciprocal discovery. That's just not fair. If they have a case, if they have a position, we have the right to know it in advance. We have a right to think about our response to it. We have a right to work out our response to it. We have a right to search and shepherdize cases, and they have no right to blindside us this way.
Well, Mr. Dershowitz, you filed a response to the motion, citing cases and authorities. Prosecution chose not to even do that. What does that tell a court? So maybe you're all wound up about nothing.
Well, no, you may be right, Your Honor. It tells us that the court believes that the government's position is at least ambivalent or not.
If the prosecution chooses not to even respond in writing.
Well, we accept that. And the reason the Fagan case supports us is
Yo,
because
that
in
was
Fagan, the issue was simply whether or
Counsel,
not.
I've read the Fagan case.
Right,
I'm familiar with Judge Granlin,
right.
Justice Fukudo, Justice Boren.
In light of Your Honor's statements, I think I have nothing further to say.
Thank you.
Your Honor, before you say anything more in light of the court statements, I want to let the court know that we are very seriously opposing the release of these transcripts for the reasons which I've revealed. Please do not take our failure to file a brief as any indication that we're not. In addition, when the court first called us for hearing, I stood up and said their response was untimely, the ACLU supplemental brief was untimely. We were willing to waive untimeliness if they're willing to waive the citing of this case. I don't know what we're bickering about with regard to that now. But the point is, Your Honor,
Well, no, Mr. Dershowitz indicated he had reasonable opportunity to read it. He's argued it.
I want to ensure that the court is satisfied that the prosecution feels the court has had good cause all along to maintain the confidentiality of those proceedings which resulted in the sealed transcripts, that as a matter both with this particular case and for public policy reasons for future cases, the court should maintain that confidentiality. And I want to make the final and what is fairly obvious point that the defendant is having a very, very public trial, and the court has been very generous in allowing the cameras to remain in the courtroom throughout these entire proceedings. We are talking about a very small portion of an otherwise very, very public trial, and it does not just because the press wants to know this information does not mean it's in the best interest of the public, when you weigh all of the concerns of the public, to release it.
Thank you, counsel. Well, I think this is a situation where we'll let the public decide what's in the best interest of the public. The court will undertake to redact the personal identifying information of the jurors involved, and so counsel are aware the court did on many of these circumstances independently on its own motion call witnesses, examine witnesses during the course of these proceedings. The court will redact from the transcripts names and places of employment, other identifying information. There are several hundred pages of these transcripts in several volumes, perhaps dozens of volumes, maybe 30 volumes of proceedings that the court has conducted with regards to these. So they will not be immediately available. You should anticipate release of these transcripts, close of business, July 3rd. That should be sufficient time.
Your Honor, may I just ask one question?
Certainly,
What about
counsel.
the underlying documents and things like that that may have...
I'll
come
make
up
that
in-
available.
Excuse me?
I'll make that available.
Thank you, Your Honor.
All right. There's an old Chinese saying, be careful of what you wish for. Thank you. Good morning, counsel. Back on the record in the Simpson matter, Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Thompson, Mr. Neufeld, people represented by Ms. Clark, Mr. Clark, and Mr. Darden. Jury is not present. Counsel, anything we need to take up before we ask the jurors to join us? No. Deputy Mayor, let's have the jurors, please.
Well, at least Miss Lewis stopped talking. There's that. Oh no, we're back to Dr. Weir. Oh no, we have Dr. Weir today and tomorrow. Then I think we're done with him. Hi, Dr. Weir. How are you?
All right, good morning, Dr. Weir.
Good morning, Your Honor.
Doctor, you were reminded, sir, that you were still under oath, and Mr. Neufeld, you may continue with your cross-examination. You're welcome.
Good morning, ladies and gentlemen. Good morning, Dr. Weir.
Good morning, Mr. Neufeld.
Dr. Weir, is it your position that the appropriate or ideal, let's call it the ideal database in a criminal case for analyzing DNA evidence would come from a census of the population of possible perpetrators?
Oh, well, do you understand the question?
Yes, I'm thinking, the word census means a complete enumeration. I suppose that would be ideal. That would be beyond practicalities.
Well, have you ever, in fact, stated that in your own articles, in your own writing?
I probably have, yes.
In fact, I think, could you explain, by the way, what that term means to the jury?
Which one was that?
That the ideal database would be the population of potential perpetrators.
Oh, certainly. That's, and I think that's quite a good point. What we're trying to do is to estimate the frequency of one of these absent profiles. We want to know how often something occurs, and the way to answer such a question is to go out and see how often it occurs. I mean, the ideal, and I say ideal in the meaning that's the sort of the ultimate extent, is to go out and type everybody in the world. And that would be certainly wonderful, because then we would know, when we saw a profile, how many times it occurs. I think I said
It's
on
because
Friday,
women
or
are
maybe
crazy.
Thursday, we can't
Women
even count
are
everybody
crazy.
in the world, let alone profile them.
Now, I think also in your writing, sir, you used as an example in a criminal case where the police were actually able to go out there and type the entire reference population of possible perpetrators. This was a case in England, in Leicestershire.
Yes, that was the first criminal application of DNA. It was an interesting case for many points, but indeed the crime was committed in a village, and the police got blood from everyone, I think in actually 2 adjacent villages, something like 5,000 people.
And in that case, what they did is they typed all the male members, I believe, of those 2 villages.
It was a rape murder, so they typed all the males, yes.
And so that would be an example where in fact, you have a database comprised of a census of the population of possible perpetrators.
Well, it wasn't a database. They didn't do any frequencies. They just typed everybody and found the person who matched.
Now,
So there were no calculations done. I just didn't. I wanted to clarify the word database.
okay. But they at least had data on the entire population of potential perpetrators, at least in that case.
They had typing on just a very small number of loci. Yes.
And would you agree, sir, that in each case, each case defines what would be its own appropriate population of potential perpetrators.
That's right. We always, when there is a case and there's a matching profile, there are two possibilities. Either we know who the profile came from, or we don't know, but this unknown person's got to come from somewhere. And as Mr. Neufeld said, it's convenient to call that group of unknown people the population of potential perpetrators. It's a funny phrase.
So for instance, in this particular case, where Mr. Goldman and Nicole Simpson Brown are killed in a place somewhere in Los Angeles, in the area called Brentwood, would the population of potential perpetrators include those people with a certain geographical proximity who could potentially have committed this crime? Would it include those people?
It would certainly include those, among others. That may be the most natural description.
And when we say include, that would mean at least including the people of Los Angeles, or the greater Los Angeles area, if you will.
I'm not sure how wide a net you would want to cast, but that sounds reasonable.
Okay. Now, in this particular case, sir, did either Cellmark or the Department of Justice rely on a database comprised of the population of potential perpetrators?
Not in this case, nor in any other, because the population of potential perpetrators is not sufficiently well defined that it can be sampled.
Well, you've also written, I believe, Dr. Weir, that shy of doing a census of the entire population of potential perpetrators, the next best approach would be to take a representative sample of that population of potential perpetrators. Is that correct, sir?
Yes, we can't get everybody. A sample from the, it's going to be easier if I say the irrelevant population. If we could do that, we would. It's almost always the case in a crime that population is not sufficiently delineated. You know, we've said that this one could involve Los Angeles, it could involve San Francisco, it could involve someone who's just hopped off a bus, committed a crime, and then hopped back on. So it's very difficult for us in practice to say which group of people there is that we should be considering. So because we can't describe it, we can't take a sample from it.
Dr. Weir, do you have any published evidence that would show that the multilocus frequencies in the Cellmark and DOJ databases are the same as the population of potential perpetrators in this case?
Oh, I can't do that for any case. The population is not defined well enough.
And would you agree, sir, that the databases that were relied upon in this case are not even representative of the population of potential perpetrators for the crimes committed in this case?
Well, that's really confusing things a bit, I think. It's not representative in the sense it doesn't contain people just from this area. It's representative, however, in the sense that the frequencies we obtain from the Cellmark or the FBI databases are applicable to the crime in this case.
Well, sir, would you agree that, for instance, not even large segments of the population of people who live in Los Angeles County are reflected in any of those databases that you relied upon from either the FBI, the Department of Justice, or Cellmark?
Well, I agree in the sense that those specific people, but I disagree in the sense that people with those profiles, we have a lot of experience now from FBI and Cellmark and many other laboratories in this country and around the world showing that whenever we make calculations, each calculation differs according to which database we use, but they don't differ in the sense of importance, in that a profile is very rare in this population, which would be very probative, or very common in this population, which would not be very interesting. So we find great consistency in the conclusion that these multi-locus profiles, these complex DNA profiles, are rare no matter which database we use.
I'm sorry, but Dr. Wood, didn't you say just on Friday that, for instance, for the various PCR markers, that you see large swings in certain profile frequencies between different racial populations, be it black, be it white, or be it Hispanic?
Well, yes, for the PCRs, the numbers are much smaller. The proportional differences are quite large. The actual differences are not. You know, we're going from tens to hundreds, maybe to thousands, where you're getting a range. Of course, that's a big range of numbers. But we didn't start out by saying the PCR profiles are extremely rare. No one's ever claimed that. The RFLP profiles are extremely rare, no matter which database we use.
Now, Dr. Ware, returning to that issue of whether or not the databases that you relied on in this case are representative of the population of potential perpetrators. Are you aware of the fact, for instance, that California has the largest concentration of Asian Americans in the United States?
I'm not aware, but it doesn't surprise me.
Okay. And, sir, the databases that you relied upon in this case, well, and furthermore, are you aware that there is a very substantial Asian American population residing in the greater Los Angeles area?
No, I'm sure that's right, yes.
Okay. And so would you agree that the databases that Cellmark relied upon in this case do not include Asian Americans?
Well, of course they don't, but I think I've explained that I don't believe that matters, because when we examine Asian databases, we still find that an RFLP profile is rare and a PCR profile is in the same ballpark as from the Hispanic and African American and Caucasian. Your point's quite valid. There are no specifically designated Asian databases used in this case. I don't think it's going to cause us any misunderstanding of the nature of these profiles.
And sir, not only are there no Asian American databases from Cellmark, but again, you agree there's no Asian American database that you've relied upon here in analyzing the DOJ or FBI work, isn't that correct?
No, I haven't used Asian. I've used the Hispanic, African American, and Caucasian, three somewhat different racial groups, and their frequencies are consistent in that the whole three of them tell us the same story. The RFLP profiles are astonishingly rare, and the PCR profiles are rare but not astonishing.
Well, and that the PCR profiles vary considerably depending upon which database you use, isn't that correct, sir?
And proportionally, but not in absolute terms. They're still in the range tens to hundreds to thousands.
Sir, with
I think you finished.
Sir, with respect to the PCR databases, wouldn't you agree that there are, in your terms, statistically significant differences between the various ethnic groups?
Well, I'm not sure on the profiles. We'll have to examine each one specifically. The numbers are different. If they're significantly different, we mean is one included in the confidence limit of the other.
I'm sorry, did you finish your answer?
No, I hadn't. Now, for the profiles consisting of PCR, typically or up to 14 bands with a 7 PCR, each one of those 14 bands by itself can differ markedly. We've got some numbers here. They can be 2 or 3% in one database and maybe 20% in another, and an astonishing difference for each individual item. And some people have got very upset about this difference for each band. That's interesting, but it's misleading in that we are not using individual bands. We're using the whole package. Now, if I have a band which is more frequent in African Americans and less frequent in Caucasians, it almost has to follow that another band must be flipped around. We've got to have some balancing out between the databases. It just couldn't be otherwise. So when we multiply together these varying bands, the whole package, the whole profile, doesn't differ as much as the individual bands.
So just to cut to the numbers themselves, if you look, sir, at the table, you have the 3 contributors for the various mixtures. Could you look at that for a second?
Certainly. This is the one I gave you this morning.
Yes. Now look at item 29 on the steering wheel.
Yes. Now, these are all the PCR profiles, right? Mm-hmm.
What is the most frequent profile for a 3-contributor mixture for item 29?
Well, this comes if these 3 unknown people that we're supposing we don't know where this profile came from, if those 3 were African American, Southeast Hispanic, and Southwest Hispanic. In that case, the profile would occur 1 time out of 4.
It's 1.
Excuse me, I've misspoke. 1 out of 2.
1 out of 2?
That's right.
Okay. That's if the mixture came from an African American, Southeastern Hispanic, and a Southwestern Hispanic,
Yeah,
correct?
well, I thought so. It's actually 2 African Americans and a Caucasian. I apologize.
2 African Americans.
And a Caucasian.
You want to start with a new page?
Thank you, Your Honor. So this is going to be for 3 contributors. Now, would you please tell me what's the most common profile?
That one, the 2 African Americans and the Caucasian.
2 African Americans and a Caucasian.
Right.
And what is the frequency of that 3-contributor mixture, sir?
1 out of 2.
Now, according to these databases that you relied upon, could you please give me the racial or ethnic mix of that group of people which would have the rarest frequency?
Certainly. This is if the whole 3 unknown contributors were all Caucasian.
And, sir, how rare or common would that frequency occur, given your databases?
1 in 3,500.
1 in 3,500. Is that right?
That's correct.
Would you agree, Dr. Weir, that the difference between a frequency of 1 in 2 and a frequency of 1 in 3,500 is extremely significant?
Well, I'm going to have to do it in two parts. Of course it is, and I should explain why the difference is so dramatic in this case. I woke up this morning at 5 and thought, how can I possibly avoid embarrassing myself again in court? And I thought, I'll do every conceivable thing to make these frequencies as conservative as possible. And I noticed that I believe item 29 has an LDLR, has a polymarker component to it. And I noticed that in the African American database there was a suggestion, just a hint of some dependence between components of the polymarker. So I took out some of the information for the African American contributors to item 29, which is, so really we're comparing, I think this is appropriate numbers, but we need to keep in mind we are comparing profiles with different numbers of bands in them.
All right. And sir, just as your calculations and your databases did not include any Asian Americans in them, would you agree that in the Los Angeles community there are various people of different Hispanic origin?
Oh, yes, I would go further. I think when we come down and look at people in particular, if we went round the room, we'd find that we each have different ethnic backgrounds if we go back far enough.
To your knowledge, Dr. Weir, does either the DOJ databases that you relied upon or the CELMARK databases for their Hispanic database contain people who originally are from South America as opposed to being from Mexico?
Oh, I have no idea.
In fact, you have no idea whether there are any people in these databases from, say, Colombia
No, I have
who
no
have moved to the
idea.
United States.
I have no idea.
Now, Gary Sims said that he relied on the FBI's RFLP database. Are you aware of that, sir?
I think DOJ uses those databases from the FBI, yes.
And are you aware, sir, that a substantial portion of the FBI's Caucasian database is comprised of 220 self-described white FBI agents?
What's the self-described? That they are FBI agents.
Well, I'm sorry, the self-described refers to their ethnicity.
Oh, certainly. Well, yes, as all the databases do, yes.
You're aware of that?
Yes. Mm-hmm.
In your opinion, Dr. Ware, would you consider 220 white FBI agents to be within the population of potential perpetrators for the murder of Nicole Brown Simpson and Ronald Goldman?
From the point of view of RFLP profiles, I would, yes.
Okay. And
Because their profiles, actually the FBI agents is a lovely collection of people because they're from all over the country. And although they say, as Mr. Newfield said, they self-describe themselves as Caucasian, we can be sure they have quite different European backgrounds. So this is really a lovely mixing up. We've got people from all over, each contributing their own unique profiles and making sure that the FBI's database represents the whole of the United States. I think it's good.
Okay, Dr. Ware, how sure are you as to the fact that whether or not the FBI's 220 white FBI agents represent European backgrounds from all over Europe? Do you have any personal understanding on that subject?
Oh, I'm just relying on my common sense there.
Just your common sense?
Yes, sir.
You have no personal information as to the ethnic origins or national origins of any of those 220 white FBI agents, do you?
Or them or anybody else in any of these databases.
I see. And in fact, Dr. Ware, you said that other people in this white FBI database come from other parts of the country. And I think you said all over the country. Is that right?
No, I said the FBI agents would be from all over the country.
Right. Now, other portions of the white database come from Texas, I believe you said, right?
Well, the FBI Caucasian database has actually 4 origins. There are FBI recruits. There are people who have given blood donors from, I think, Miami, somewhere in Texas. I'm not sure if it's Houston or Austin, and somewhere in California here.
Yeah.
It's probably Los Angeles.
Well, probably Los Angeles. Do you know for a fact that it's Los Angeles?
I think I've read that, yes.
And
That's
do you know for a
3.
fact
You
that
said
they
there
are
were
actually
4.
blood donors or from some other source?
I thought it was blood donors.
Because she's shown me the source of information that you're relying upon when you say that the sources of subjects from California are derived from a blood bank.
Well, I'm going to have to cite my own paper in 1992, and then when I wrote that, I checked with Dr. Badoli, and that was my understanding at that time.
In the 1992 paper, do you say that they come from actual blood donors in California?
I think I did.
Okay. Now, you mentioned that as to the white database of the FBI, that 220 FBI agents are included in that white database. Are you aware of the fact that the FBI's African American database does not include any FBI agents?
No, I'm not aware of that specifically, no.
Well, are you aware of what the source of the FBI's black database is?
It's parallel to the Caucasian. That's the blood banks from those 3 areas, Miami, Houston, and Los Angeles.
Okay, so if it's just the blood banks from Miami, Houston, and Los Angeles, you have not included in that group any African-American FBI agents. Isn't that correct, sir?
That's absolutely correct.
And, sir, are you aware that the reason there is no African-American FBI agents in the FBI's African-American database is they don't have sufficient numbers of African-American FBI agents working for the FBI?
Well, that makes sense. They just probably didn't choose to separate out that group if it wouldn't be numerous enough.
So you're aware of the fact that these databases are really nothing more than convenience samples. Is that a fair statement?
Oh, they are the best things we can do. If we call them convenience, that's a good term. We've got to get blood from people. It's hard to get anything from people, and it's very hard to get blood from people. So it makes sense to go to the place where the blood is kept, the blood banks.
Well, Dr. Ware, as opposed to convenience samples, you would agree that the samples used in these databases are not what statisticians refer to as truly random samples. Isn't that correct?
Well, they're not truly random. That would require us to list the population and take a sample from this list or some other scheme. It's unnecessary to do that. And I say that on the basis of what we see in databases collected under a variety of rules within this country and around the world. We just don't get led astray by using these FBI databases.
Dr. Ware, a moment ago you said that taking these blood bank samples is, I believe you said, a wonderful source of samples for analyzing this data. Is that correct?
Yes, certainly.
Now, Dr. Cotton testified several weeks ago in this case that the 1992 Cellmark database for African Americans is derived from 150 people who made contributions at a blood bank in Detroit. Are you aware of that fact?
Not the details, but that sounds right.
Now, sir, do you have any idea how ethnicity or race was determined at that Detroit blood bank?
No, but what I'm hoping is that it was self-reported. And I think there is very easy to overstate the ethnicity of these databases. Ethnicity is, we now know, it's a very vague term genetically. We may look different, but underneath we are extremely similar. So although it's interesting and maybe convenient to label these databases African American, Caucasian, and Hispanic, it's sort of overstating the differences. For these profiles, particularly the RFLPs, they just don't differ very much in frequency.
But Dr. Ware, you're aware of the fact that the laboratories who did the work have chosen to rely on those racial and ethnic classifications in their databases. Isn't that correct?
Well, I don't know that I'd say rely. They keep them separate, and this has the advantage that we get different answers so that it's clear to us what difference it makes if we go to different sets of people. It sort of makes my point. It just doesn't make a difference. I would be just as happy if they amalgamated all the databases into one and just gave a single figure. But by giving a range, if you like, they are being very open and saying, well, I've used 3 different samples and this is how they differ, and they all tell me the same thing. These profiles are very rare.
Dr. Ware, a moment ago you said you do not have any knowledge as to how ethnicity or race was determined at that Detroit blood bank. Is that correct?
I don't have any knowledge, that's right.
And, sir, would it be fair to say that you also have no knowledge how ethnicity or race was determined for any of the FBI databases?
Well, I have no knowledge, but what I'm hoping is that it was very vague.
I'm sorry, I just asked the last part of the answer to be struck. I'm asking what he has knowledge about. Well, if, in fact, you mentioned the method a minute ago of self-reporting. You remember that?
Yes, sir.
In other words, where a person comes in and gives blood, and the nurse or phlebotomist says, what race are you? And the person says, I am white, I am black, I am brown, I am green, I am whatever. Okay? That would be self-reporting, correct?
That's what self-reporting means,
Right.
yes.
And would you agree, sir, that self-reporting is not a scientific method of classifying people by race?
Mr. Newfield, I don't think we understand what race is at a genetic level. We had a very interesting conference in Atlanta last fall where this was discussed extensively and reported in the newspapers. We now know as scientists that the whole idea of race is a very vague one genetically. So what I'm hoping is that people don't get too detailed and specific about their race, whatever they choose to call themselves. What I'm more concerned is that we have a sample of people from a wide basis possible.
Dr. Ware, please answer the question.
Sustained.
Dr. Ware, if the Detroit Blood Bank relies on self-reporting of the individual donors, would you agree that that would not be a scientific method of classifying people by race?
I think the question's confusing in that it doesn't make any difference what the people are called. They can call themselves Martians and we'll still get the same conclusions, that these profiles are rare. I think that the reporting of racial groups just is irrelevant.
Dr. Ware, you have reported data in this case based on racial groups, have you not?
I've used the databases as supplied to me, and those are described by racial names.
And have you, in fact, expressed ranges in your testimony that are predicated on race as well?
Yes, because that makes it very, very clear what I'm talking about. It shows the effect of using different databases.
So, Dr. Ware, I now ask you, do you agree or do you disagree that simply relying on self-reporting to determine one's race is not scientific.
I don't understand the question. I'm sorry. The scientific meaning how we should calculate profile frequencies, I think what they've done
I
is
have to go
most
get my
appropriate.
phone. I have
Dr.
a text
Weir,
message.
If
Hold
a person
on.
who drew the blood simply
Be
wrote
right
down
back.
race based on the self-reporting, would that be a scientific way of determining someone's race?
For the purposes of these calculations, I don't think it matters what the person writes down.
I didn't ask you whether it matters, sir. I asked you whether it be scientific. Can you
Well,
answer that question?
I can answer the question in the context of what I'm doing here, and I think in the context of what I'm doing here, it just doesn't make any difference.
I didn't ask you whether it makes any difference, sir. And, Your Honor, I would ask that the witness be instructed to at least answer the question.
Nope. The way you phrased the question, he's giving an answer within the context of his expertise.
Do you have an opinion as to whether or not it is scientific to simply rely on someone self-reporting that I am either African American or Caucasian or Hispanic as a means of determining which database that person fits into?
Certainly, I think it's most appropriate.
And you think it's scientific?
I think it's appropriate for doing the scientific calculations. When you say is it scientific for this context, yes, I think it is.
Okay. And how about if the person in the blood bank simply relied on his or her observations of the blood donor to determine which race the individual belonged in? Would that be scientific?
Well, given what I've said, that is just as appropriate. It's just as arbitrary as self-reporting. I think it would be fine.
Dr. Weir, if it makes no difference how someone describes themselves and what database they fit into, then how do you explain the huge differences on that board between 1 and 2 if you have people who are 2 African Americans and 1 Caucasian contributing to the mixture versus a frequency of 1 in 3,500 if you have 3 Caucasians contributing to the mixture?
Oh,
Well, the difference is partly with the different number of bands, but the more important difference is that we are based on 4 different samples. We could very well have found the same range from 4 samples of Caucasians.
But you couldn't find it in 4 different Caucasians in these databases, could you?
I have only 1 Caucasian database.
And that's what you relied on here.
Yes, certainly.
Okay. So wouldn't you agree that when people simply report their race, if asked, say, at a blood bank, that that's not done in a scientific fashion?
haven't we asked this question now about 8 times?
I modified the language thinking that perhaps this will give the witness a different answer.
Please restate it. Excuse me.
Do you believe that people who are reporting their race when they go to a blood bank, that those
I am so proud of you, Chinny. I hope you're not sick. But I am so proud of you for taking a sick day. Guys, so I know when we grew up, we were taught work ethic. Strong work ethic. I know the people in this chat have a strong work ethic. I know that. That's not what you remember in your later years, guys. You don't remember the days you went to work. You remember your sick days. You remember the days you played hooky. You remember the days when you had fun. Take your sick days. Take your sick days. Jenny, I'm so proud of you. I hope you're not sick, though. I loved that. I loved that, Josh. That was so funny. I saw it when I was at work, and I don't have time to reply or anything. I look and I move to my next table.
those descriptions would be consistent with doing this in a scientific fashion?
Well, I can't answer unless we talk about what it's used for. If it was used to construct an evolutionary tree of the evolution of races of man, then it would be very important. If it's used to calculate forensic profile frequencies, I don't mind what they say.
But the reason you say you don't mind is because you don't think race makes a difference now. Is that correct?
That's correct.
Oh,
And you don't think it makes a difference, notwithstanding the example that I put on that board, which is, I don't think we gave a number to this board, Your Honor.
nope,
Could we, what is next in line?
1206.
1206?
Is that correct, Mr. Douglas?
And you don't think it makes a difference, Dr. Ware, notwithstanding the example that's reflected on Defendant's 1206, isn't that correct?
Well, as I've explained, there's a little wrinkle here, but if I had kept the same number of bands, the numbers would still have been different. There's a range for every profile over all these 4 databases, and I think the range would be similar if we took different databases of the same ethnic background. So the numbers are different, and I think that's very informative. It gives us a very concrete feeling of what these numbers are saying. We don't know what the frequency of a 3-person pool of DNA is. We're trying to convey some sense, and in this particular case, it can be quite common, 1 in 2. It can be moderately common, 1 in 3,000. But now we have laid out all the calculations, and we've got a very good understanding of the variation that we get by taking different samples. I think it is the best possible way to present this information.
Dr. Ware, didn't you say either early Friday morning or late Thursday afternoon during your direct testimony that there is, in your opinion, substructure within the different racial and ethnic groups? Recall that?
Yes, there are groups of people. If we could identify a group, just put a rope around a group of people and say this is a group of people and measure their frequencies, they would be different from another group and another group.
Sorry. And so, for instance, even amongst Caucasians, you would, if there is this thing called substructure, and that there are different groups of Caucasians who may have different genetic frequencies for particular alleles than other groups of Caucasians, then for some of those groups, an allele could be much more common or more common than for other Caucasian subgroups. Isn't that correct?
Yes, I think you've captured the essence of it. It's the specific alleles that differ one group from another. It's the profiles, the collection where the differences balance out that don't differ very markedly.
And so these databases, though, do not break people down into those various subgroups for which there may be different allele frequencies. Isn't that correct?
The databases don't, but the calculations I do can take that into account.
The calculations that you say you do take that into account. Is that correct?
That are now being done by myself and several other people. Yes.
Okay. But the calculations being done by Cellmark that Robin Cotton offered in this case do not take that into account, do they?
No, they give the single estimate. They don't do this extra step.
And the calculations that Gary Simpson, the Department of Justice, delivered to this court also don't take that into account, do they? Does it?
They don't take it into account. Of course they do. What they have done is give the different racial groups. So they have conveyed a sense of how much variation there is in frequencies. They, instead of taking the subgroups within the Caucasian and looking at those differences, they've taken the differences between Caucasians, African Americans, and Hispanics. So they've given a sense of how the answers vary.
Well, let's talk about that term Hispanic for a second, Dr. Weir. Cellmark used a database in this case which they characterize as Hispanic. Is that correct, sir?
That's right, yes.
And wouldn't you agree, sir, that Hispanic isn't even a race? It doesn't define a race.
It's a very vague term. It almost means none of the above in the census forms. Mm-hmm.
So would you agree it doesn't define a race of people?
It doesn't define a race, and that's, just to go to the next point, it doesn't have any relevance whether it does or not in this context.
Okay. And in fact, when Cellmark is using the term Hispanic, what they're simply saying is that these are people who contributed blood who have an Hispanic-sounding surname. Isn't that correct?
I don't know that.
So you have no knowledge as to what the criteria was for putting somebody in their Hispanic database, do you?
Oh, I imagine there was a reason for calling, either they or someone calling the blood donor Hispanic, but as I've said, in several different ways now, that's fine.
Well, Dr. Weir, wouldn't you agree, again getting back to the issue of subgroups and substructure, that, for instance, people who have an Hispanic surname, who have a lot of, let's say, Central American Indian blood in them, and they're living in, let's say, Southern California, may have very different frequencies for particular alleles than would people with Hispanic surnames living on the East Coast who maybe come from Puerto Rico and have African blood and Spanish blood in them. Would you agree with that?
Well, you can refer to my paper where I show that the frequencies are statistically different. Sometimes a locus for the RFLP has 15 different types. We can put them to 15 different categories. When I do a test between Miami and Houston, 14 of those 15 frequencies are different at a particular locus. And that doesn't surprise me. As Mr. Neufeld says, people who, someone has called them Hispanic living in Miami, they have a very different background from people living in Houston. The important thing, as I went on to show, to demonstrate in that paper, when we amalgamate all the bands from all the loci, the profiles don't differ to an extent which would be misleading. Sometimes the profiles are not even statistically different. Sometimes they are, but they always convey the sense. A 7-locus RFP profile is a rare phenomenon.
But nonetheless, you would agree then that the Cellmark database, which they characterize as Hispanic, is, I guess, after what you've just said, a rather meaningless term. Would that be fair to say?
Oh, it's not meaningless. There is some rationale, after all, for someone being called Hispanic. It's a convenient label on the database. It's as good a name. They called it. I would have been happy if they called them databases 1, 2, and 3.
But that convenient label of Hispanic has nothing to do necessarily with the race of the individuals who inhabit that database, does it?
Well, I don't think it can because we don't know what race means. So I don't, I'm not trying to be evasive. I think we just don't mind what race a person is. We're concerned with their profile frequencies.
Well, sir, how do you define someone as African American for putting them into an African American database?
Unfortunately, I don't have to.
Well, you've relied on Cellmark's descriptions of their databases, have you not?
I have taken the databases and they have labels on them, yes.
Okay, and you've relied on the FBI's databases, and they too have labels on them for different races, don't they?
They have 4 databases with labels which have racial names, that's true.
And you've been consulting to the FBI, I believe you said, since 1989, haven't you?
That's right, I have.
And you and your university has been consulting to Cellmark for almost as long a period of time, haven't you?
Yeah, for some time, yes.
Well, let me ask you this. Given the characteristics and descriptions that Cellmark and the FBI use for putting someone in their white database, or their African American database, or their Hispanic database, where would you, as the advisor to these people, put, for instance, the children that are the product of Mr. Simpson, O.J. Simpson, and Nicole Brown Simpson? Which database would they go into, according to their criteria?
I'd be happy to flip a coin. I don't think it's going to make any difference to the calculations, how a person is classified in a database. It's a convenient way of identifying different samples of people. The samples are all giving us the same kind of an answer, and I don't think it makes any difference.
Well, I'm sorry.
I don't think, when you come down to it, I'd be hard-pressed to define my own ethnicity precisely. I'm obviously Caucasian, but I have grandparents from different European countries, and I differ from other Caucasians in the room. I don't think it matters.
Well, Dr. Weir, if you don't believe in these classifications by race as being relevant, then how in good conscience can you sit here and make racial classification estimates as you did Thursday afternoon, Friday, and apparently today as well?
Sustained phrase question.
I'll move on. In this case, Dr. Weir, when you provided a statistical estimate of the value of a certain piece of biological evidence, such as, let's say, a blood drop stain at the Bundy walkway, or a drop recovered from the rear gate, you made certain assumptions, did you not?
Well, yes, do you want to go through them, or what?
I will go through them. I just want to at least establish that certain assumptions were made.
All the science is based on assumptions, yes.
And I believe, as you stated in your report, one of the critical assumptions that you have made for all your calculations is that the laboratories made no errors in the processing of the evidence. Isn't that correct?
Oh, I can't even address that in the sense I just don't know what the labs did. They give me their reports and I just go from there.
Well, but in your report that you submitted to this court and to counsel, you have a discussion of error rates, do you not?
Well, it's a disclaimer in essence. I say whether or not the laboratory made a mistake, it's really beyond my expertise and knowledge, so I'm just going to go with what they said.
Well, but you also said that you are assuming that no errors were made. Isn't that correct?
Well, my calculations start with the data, so that I said that, but it really means the errors, any errors at any stage just don't have any impact on my calculations. My calculations are frequencies of profiles.
Didn't you state that your calculations in this report assume the validity of all the DNA profiling done in this case?
That's right.
We have covered this once before,
Leading into a new subject, Your Honor.
I assume.
No, we're not. I ate a few extra minutes today because we will not get done with him tomorrow, but we will get close. We'll get very close to finishing with him tomorrow. So that the next day we're going to hear a little bit of it, and then we're going to move straight into Marshall Clark talking about something. June 26th. The last part is when Marsha comes up. Hold on, let me show you what I'm seeing. Okay. We're right by the highlighted one right now. We're 40 minutes into it, so we have like an hour and 10 minutes left. And then we have a 2-hour one with Dr. Weir. I don't know how long Dr. Weir is on the stand in that 2-hour one. He might only be on the stand for 10 minutes. I don't know. He could be on the stand for 2 hours. Then we have this hour and 27-minute video. Again, I don't know if Dr. Weir is in it. Like, he might be in it for the entire video, and then Marcia comes up at the very end, and that's the screenshot they took. Or he might be done here. I don't know. We don't know. But we felt like we had forever of him to go, and we are almost done with him. And then Marcia, somebody else in the witness stand. Marcia, I don't know who that is. A lot of Marcia. I am just hoping Marcia is going to talk about prior domestic violence. I mean, I don't hope for that, but I hope for that. Because we got to get to it soon. Dearden. It's so hard to figure out what's happening. These look like three different witnesses. Bam, bam, bam. July 10th. It looks like we're right there. We're right to the defense's turn. I am so ready for that. We deserve it. We're so close. Let's not give up now, guys. Hold on, let me make sure this is perfect for tomorrow. Perfect. Go get a sub. Drink it with a beer. Eat it with a beer. Alright, guys. Have a great day. I will see you again soon, I promise. Bye, guys.